Would you like to be able to cut your bar exam study time in half? Stay tuned for today's message on myths. I'm going to show you just how you can do that. I'm Jackson Mumey, the owner and founder of Celebration Bar Review, and for the past 25 years I've helped thousands of bar takers, people just like you, to make their next bar exam the last bar exam. If you want to know more about how we do that, check out the links on this page after this video. Well, here we are at the last of our 10 myths about the bar exam, ways that you can improve your performance by avoiding these problem areas. Just to wrap up very quickly and to recap, in case you missed any of the earlier videos, myth number 1 was titled, "It's All About Me." Number 2 in our list of myths was, you need to practice more questions. Myth number 3 was, work harder. Ooh. Myth number 4, it's not fair. Myth number 5 on our list was fool me once, all about how people try to game the exam. Myth number 6 was you gotta know the law cold. Well, you've heard that one before, I'm sure. Myth number 7 was, but it worked in law school. And myth number 8 in our list was you need to spot all the issues. Oh, that's a great one. And myth number 9 was the famous bromide, don't repeat the facts. All right. If I could do a drum roll, I would. But the number 1 myth that I have found in over 25 years of preparing thousands of students successfully for the bar exam is the following: memorize this. In other words, this is the myth about memorizing and reciting the law as the way to learn and to be successful on the exam. It's the thing that most bar takers think they're going to be required to do in order to study and pass, and it is the thing that they spend a substantial amount of their time and energy working on. I would say up to 50% of the time spent studying is really time spent memorizing and then reciting, whether it's in an essay or for the multi-state exam, whatever part of the test or the state multiple choice part. Memorize, memorize, memorize. Not a week goes by that I don't hear from students asking, should I create flashcards? Should I make extra outlines? Should I create mnemonics? Should I create mnemonics for the flashcards, for the outlines? You get it. It just goes on and on. Now, here's the reason that this is a myth. If you've been in practice or you've had occasion to see attorneys in practice, I want to ask you quickly, when's the last time that you saw an attorney actually memorize and recite anything? Something. I'll wait. Oh yeah. They don't, do they? You see, it's really not about memorization when it comes to the actual practice of law. Today we have all sorts of tools that we didn't have 20 years ago, 30 years ago, certainly not 45 or 50 years ago when the bar exam really took over its present form. Today, you can use everything from Westlaw and Lexis to more sophisticated but commonly available tools like Alexa, Siri, Google, and Watson to get answers to legal questions. You don't need to be someone that goes out and memorizes the law. That's not what your clients are paying you to do. Now, there may have been a time long, long ago, way before our era, when memorization and recitation were in fact important. You know, if you read Lincoln's Team of Rivals by Doris Kearns Goodwin, it appears to me from that book that most of the folks in Lincoln's day who were practicing law, or reading the law as it was called then, were in fact memorizing. I think that was certainly true from that era right on till about the 1970s or 80s. And then it started to shift. Today, the shift is really complete. There is no memorization in the law. Now, here's the reason that that becomes an important distinction. The bar examiners, contrary to some opinions, don't live in ivory towers. They are not academics, actually. They actually function out in the real world, and they have to deal with something called judicial economy, which means the efficiency of dealing with judges, attorneys, juries, opposing counsel, clients, the communities that they serve. In that capacity, they recognize, as anyone who is actually functioning in the world of the law, that memorization simply doesn't have much value anymore. It is a useless skill. It would be like being someone that shoes horses rather than repairs transmissions. It's an old skill and it's gone. You don't need to do it anymore. And if the bar exam was really designed to measure that skill, if that was the primary number 1 skill to be measured, what would that tell the bar examiners or the community they serve about someone's fitness to practice law? The answer is it wouldn't tell you very much at all. I mean, think about it for a moment, and I've used these examples in other places, but the classic is Dustin Hoffman's character in the Rain Man movie, who was an autistic savant. Or if you're a fan of old TV shows, there was a show called Boston Legal, where there was a character, Jerry Espenson, who had Asperger's syndrome. These were people who could recite and memorize, but they had no people skills. They had no common sense. They had no ability to take the information that they had acquired and then use it. Now, here's where it gets important. What's a lawyer really required to do? Why do we call a lawyer a counselor? It's not because of their ability to memorize and recite, but it's because of their ability to use what they know and to put it to good measure, to put it to the advice and counsel for their clients. And it seems to me, as I think it does to the examiners, that that's a better skill to measure than the skill of whether or not someone can memorize all the elements of tort negligence or formation of a contract or what constitutional provision goes where. That's absolutely not necessary anymore. In fact, I can today go to my devices and ask Siri to give me the elements of negligence, and I'll get that right at my fingertips. It's available to anyone. So students sometimes say, well, but I did this in law school, why doesn't it work now? And the reason is that law school is not the practice of law. They're two entirely different things. Again, sometimes people will say, well, all right, maybe I'm willing to give up the idea that I don't have to memorize, even though I did it in law school. Do I need to memorize case names and statutes? The answer is no, of course not. No one would expect you to know the statutory coding in any state or expect you to know other than a handful of major significant Supreme Court cases over the years. Nothing beyond that. It's simply not a requirement for the functioning of a good lawyer in practice, even if you did it to great success in law school. The bar examiners know this, and so when they write their tests, they don't write them on the basis of whether someone could memorize and recite. Now let's take a look at the multi-state bar exam if you're still skeptical about this. Now, that test is a test of detailed information, and many people say, well, I have to memorize all the elements to pass it. It's a, quote, black letter law test. Really now, think a little more carefully. Isn't it really a test that's got 4 answer choices, and you have to distinguish which one of those 4 is best, even if it's not entirely correct or entirely accurate? Because indeed, one could make the argument that it's not a perfect or correct answer. There is no such thing. The point is that it's the best of the 4 answer choices that you're given to choose from. Memorization by itself would do you very little good if you lack the discernment to tell the difference between one answer choice and another. In fact, very often, 2 of the choices on an MBE question will have the identical outcome, but for different reasons. And if you had memorized only the elements, well, you'd know that this is the result, but you wouldn't know why necessarily one answer was better than another. And you might be saying, well, that might be so on the multi-state, but of course in the essays I have to be able to memorize all the elements of all the law. Really? Imagine for a moment going into a courtroom in a trial and saying, Your Honor, we're here in this trial today, and before we get very far, I want to tell you all the elements in this formation of contract problem. And the judge would say, well, why, counselor? Why was that important? Well, it's not really, but I memorized them all, and I just thought you'd be really proud of me if I could show you that I know them and that I took contracts when I was in law school. You see how silly that is? You can see pretty quickly how this notion of memorization doesn't really give you much to stand on. And the examiners, I think, quite honestly would say, this isn't the kind of person that we necessarily want as a member of the bar. Therefore, if memorization is not a skill that's really useful in practice, and if the examiners don't particularly value it, why should you spend your time, your valuable study time, working on something so irrelevant? And the answer I get from most people is, well, the big box bar reviews all told me to memorize, to know the law cold, all those things that we've talked about earlier. I'll say again here what I've said before. That is more a matter of bar review economics than a matter of teaching or learning. You see, it's much easier if you have a room filled with 100 people to say to those students, now you all go out and memorize the law, instead of saying, here's how to use the law, and here's how we're going to learn how to articulate that. Because teaching someone how to use the law is much more time intensive and certainly more personal when it comes to the writing than to simply say, go learn and memorize. Now, when I see writing from students that starts off by telling me all of the elements of all of the law, I realize that immediately that person's painted themselves into a corner. They're not going to be able to tell the examiners all of the elements of all of the law, on all of the subjects, on all of the questions, on every part of the exam. By its very definition, this approach is doomed to failure. So you might honestly say, well, why would the big box bar review let people do that? The answer is that a big box bar review knows that their pass rate isn't going to change very much no matter what they do. So they take the path of least resistance. I don't blame them. And the path of least resistance is simply to tell you to memorize because it's what most of you did in law school. Now, if you want to step outside that norm, if you want to get away from following the crowd right over the 35% pass rate, then one of the fastest ways to do it is to stop memorizing and start using what you know. It also has the added benefit, literally hundreds of hours off of your study. How? Well, in a course like ours, what we do is something called spaced or stepped repetition. And while that's beyond the scope of what I'm talking about today, simply understand that there is a learning strategy that allows you to take a body of information and repeat it, put it aside for a while, come back to it and add some new information, repeat it again, set it aside for a while, and come back again, like a stair step. And when you do that, study after study after study shows empirically that people learn and know more when they study that way as compared to when they cram or they memorize. Now, throughout this series on myths, I've talked about a variety of things that help you to learn how to use the law for the particular context of the test that you're taking. You study differently for the multi-state than for an essay or a performance test because the skills that are being tested are different in every part of the exam. If you study with purpose and you study with an idea of what skill is really being measured, then you step outside that broad group of people, some of whom will pass, frankly, not knowing why, but many of whom who will not. In fact, the majority will not. And those are the people who memorize and recite. Every exam, after every exam, I have people that come to me that have taken one of the big box bar reviews and they've worked very, very hard, but they failed the test. And they'll say, I worked so hard, I memorized so much. And it's heartbreaking to see that happen. You see, it's simply the wrong skill. It is not what is being tested. And that's why it's myth number one, because it takes up so much time and energy for a bar applicant. You put so much work into it. You get those flashcards out, you write down all those notes, you work on the mnemonics until you can barely stand up, and then you come to find out, oh my gosh, nobody really cared. And that's a heartbreak, and it shouldn't happen. Now, as I wrap up this series on the myths of the bar review, I would tell you that this one that we've just talked about is the one you have to be really careful of. It's the one that can come back and bite you the hardest in terms of wasting your study time. You don't need to memorize. And if you stop and think about it, if you look at it with a clean sheet of paper, you'll realize that its core, the very logic of the idea of memorization, simply doesn't make any sense. Well, I hope this series has been useful for you. I've enjoyed going through it. I've enjoyed, as always, your comments and feedback. And as always, I wish you the very best on the bar exam and look forward to hearing from you with your successes. Thanks for joining me today.